Also to approve the agenda? Or what's the support of the agenda? All of the favor, say aye. Aye. All opposed? Motion carried. Minutes. Now it's not leaving notes. Support. You understand community? Looking for the figure of 6 minutes as presented, all those in favor? Aye. No opposed? Motion carried. First item of business, it's recommended by Catherine Kaufman, our civil assistant. Community chairman, planning commission's members of the public, one out our civil council lieutenant developments to discuss what I think is a new approach to zoning enforcement in Cheboygan County. As part of that, we'll identify zoning violations. So with that, Catherine.
And also with me tonight is Associate Attorney Nicole Essex from my firm. He does all the prosecutions, or the majority of prosecutions here in Northern Michigan, so I brought her the state chief at the video to make sure. Violations under the zoning ordinance and your zoning ordinance are a municipal civil infraction, and that's what we want. And we'll tell you the reasons why we want it to be a municipal civil infraction. But the goal of enforcement of the zoning ordinance is to accomplish it. It's not to get fees. It's not to have anybody, sent to jail. It's to get compliance with the zoning ordinance, as it is every place. All municipalities we recommend. So whatever process.
We can't hear.
Can we speak in the microphone, please?
Is it on?
To sit to speak in the microphone.
Your mic up.
Usually there isn't.
Sure. No wires going through. That's one.
Want me to come sit next to the chair first, and you turn his mic over there?
Right here.
Okay. Big pull and I just straight off. Yeah, I'm just very from. Okay, it's better. It's better. No.
Here it is. It's on. No.
Yep, you don't know still that's me. Sorry, hold on. You're not gonna say anything.
Was this one time on shade plating? It's not what it's I don't know if any.
You got the word Glenn out right here? Yeah, we're right in it.
Is that turning on? It's on. So I think that's the one. I can hear it. That's something else. That's me. That's stuff.
Something turned off.
Technology.
Okay.
I'm here. That's why it doesn't work.
I'll go sell. Okay, we'll trade sheets.
I'll just take my look and evaluate my
Sharon. No.
Yeah, you've got a new name now. Or sorry, now that's
Okay, and if anyone can't see me, I'm gonna kind of stand up, okay? Catherine Kaufman, I'm the General Civil Counsel for the county. With me tonight is Nicole Essex, who is an associate attorney in my firm. She does most of the prosecutions for our firm, for our Northern Michigan clients, so if we go to court, it's likely gonna be Nicole. The zoning ordinance, violation of your zoning ordinance is what's called a municipal civil infraction. That's different from a criminal misdemeanor. Now to explain why we prefer to enforce through municipal civil infractions. Because the goal of zoning enforcement is to obtain compliance. It's not to send anyone to jail with a misdemeanor. It's not to have anyone have a criminal record.
It's to get compliance. It's not to get fines, it's to get compliance. So municipal civil infractions allow us to do that. Whatever the process is here, usually you'll start with a warning letter or some type of correspondence from the county staff. Then there'll be a period of time where the person who may be in violation can interact with the county staff to try to resolve it short of going to court. Okay. Hopefully most of the times it resolves without going to court. If it does not resolve without going to court, there comes a point in time where the county is going to issue a citation, like a ticket. Okay. They're going to write on that ticket the day they inspected the property, and we'll talk about what inspection of property means and what the parameters and what they can and can't do. Okay. Then they're going to have pictures. They're going to take pictures of the violation that day. We're going to file a citation into court. They're going to cite the sections of the zoning ordinance, or if it's a blight ordinance or some other type of ordinance on the citation, and that's going to go into district court here in Cheboygan County. At that point, Nicole will get involved. Most likely, Nicole, sometimes me, and we'll try to resolve it with the property owner, their attorney. If not, we go to court in front of the district court. And what we are seeking is compliance. So we will have to go under municipal civil infraction. The difference is we only have to prove it by a preponderance of evidence, which is 51%. Okay. It's 51%, a lower burden of proof for us as the county. All right. We're going to be asking for compliance. We're going to ask for court costs for bringing the citation, which generally the courts won't give us that much, sometimes $500. It generally will not cover the county's costs of our time for preparing and enforcement. But if you decide to enforce, you have to bear the cost of that enforcement. So we'll go to court and then we'll put on our proofs. We'll have the ordinance enforcement officer, whoever wrote the citation will be there. He or she will go on the stand. They will testify what they observed the day they were at the property. We always send them back to the property a day or two before we go to court so they can take pictures of the current status. So that's how it goes. Hopefully the judge will find in our favor only 51%. And then, we'll be able to put on our proofs and we'll get an order from the court. We want an order from the court requiring the property owner to comply, usually within a certain number of days. And what Michael is putting up on the screen is an article my law partner wrote for the Michigan Township Focus magazine, or the MTA's general counsel, as well as serving as county attorney here, all about enforcement, talking about what's a municipal civil infraction. How do I know what to do with municipal civil infraction? What do I do if I see a violation? So that has all been distributed to each of you. You have it. You can read it at your leisure, but I'm going to just kind of piggyback off of that article. Okay. So now we're in court. We hopefully get a compliance order. We hope that the person complies within the time. More times than not, they do not comply within the time. So at that point, as part of that court order, the judge will sign a court order that generally our firm prepares that says, we have found you in violation, or the term for municipal civil infraction is responsible. We find you responsible for violating the zoning ordinance. You have 30 days to correct your violations of the zoning ordinance or the blight ordinance, whatever it is. And if you do not, the county has the right to go onto your property, perform the cleanup or obtain compliance, whatever that is, and charge the cost back against your property as if it was a tax. Okay, so that's what we hope to get. We hope to get a court order that says you have this much time to come into compliance. If you don't come into compliance, the county can go onto your property and effectuate compliance. That then requires that the county is going to hire a contractor, get ready to perform that work. Usually give the property owner another notice. So usually what we do is we send them another copy of the court order, say, we're coming on or after July 1st, get everything you want off that property by June 30th. You don't have to do that by law. We do it as a courtesy. And then when we go out onto the property to effectuate the cleanup, we usually take a deputy sheriff or police officer with us. Okay, now that's going to cost the county money. The county is going to pay the money for the cleanup. $2,000, $5,000, whatever it is. We attach it to the taxes as if it's a property, as if it's a tax lien. So we're going to get that money back eventually as the property sells, unless it goes into foreclosure or bankruptcy, which could wipe off that lien, okay? So in terms of enforcement, there has to be the will within the municipality, in this place, the county, that if we get those court orders, we are going to execute on them. Because if we get a court order and we don't do anything, it's all for naught, right? It undercuts our validity of what we're doing or that we're actually going to carry through. So sometimes, we're hired into a township that's for years never done any compliance, never any enforcement, never, never, never. And the first few times it's very challenging because we'll get the court order and then we'll go to the township board or the county board of commissioners, whoever, and say, okay, we got the court order. It's due on July 1st. We're going to send our zoning inspector out there on July 5th. He's going to see if they did anything. We can almost bet on my son's life they didn't do anything. Hopefully they did. 25% of the time they do something. 75% of the time they don't do something. So then we have to be prepared to say, okay, we're going to do it. We're going to put out bids or an RFP or something. We've got a contractor. We know it's done from that contractor. We've got a bid and it's going to cost us $6,000. We're prepared to pay that. We're going to get the deputy sheriff to go with them, and we're going to send out Michael or whoever his zoning administrator or inspection ordinance enforcement officers. They're going to go out there with the deputy sheriff. We're going to send them a letter at a time with a copy of the court order saying, hey, remember, you're supposed to be cleaning by July 1st. We're going to come out there July 15th. Anything you want, July 15th or any day thereafter. Sometimes things happen, the contractor gets busy or whatever. Give them a day, then you go, okay? And what will happen, no doubt, is at the 11th hour, the day before, they will go get an attorney to try and overturn that court order or moderate it in some capacity or tell you why you can't do it or etc. So it's really important that you all have a copy of the court order with you when you go out there again. I recommend you take law enforcement and you just execute that court order. Now, what I'm going to have Nicole talk about really is in court how she would put on a case, what she's going to need. And I just at the last county board of commissioners meeting, your new district court judge spoke. It's the first time, I have not met him. He's new to the bench. He was appointed last fall sometime. So what I think we probably need to do is talk to the court staff and make sure they're going to understand what we want. We don't want you to just find these people. We want you to issue a compliance order. And sometimes that's an educational component that sometimes each court system, we're in, several counties throughout the state, every court system does it a little bit different. What we have to learn from them is how do you want us to do it so we can get to this mutually desired. If you want us to, do you want us to write up the court order beforehand and file it with you? You want us to bring it with you? Do you want to draft it? And we say, okay, how do you want to do it? And we're very respectful of however each county court system wants to do it. But what we want is, we don't want you to just find them $100 and send them home. We want compliance and we want the violations to stop. I'll mention real briefly the reason why we don't want it to be a misdemeanor is, and Nicole will also piggyback on me here and talked about why this is harder in court. If it is a criminal misdemeanor, they have a right to a jury trial beyond a reasonable doubt. We never want to do that, okay? They have a right to, we have to have attorneys involved. What else, Nicole?
More costly to do a jury
More
trial.
costly to do a jury trial than a bench trial. Just the beyond the reasonable doubt. And a lot of times there may be a sentiment from a judge or from other people that we don't want to ding somebody with a criminal record for what's a zoning violation, right? So some judges feel that way. There's very few judges that want to send anyone to jail on a zoning violation. So municipal civil infraction is cheaper, it's quicker, lower burden of proof for us to prove, and it achieves compliance. Now, we have some cases, as we just dealt with today, we were in court today, where it's such a sticky situation and it's kind of difficult that we can go into circuit court and ask for an injunction. You can ask the circuit court judge to order and enjoin the person from continuing their violations of zoning ordinance. We were in court today on a matter like that. It was under your previous attorney, your Peter Wendling, decided to start that case with a circuit court injunction action. We are working on that today. We've got a settlement conference. I think it's gonna be pushed out a little further. But that's only in the rare case, I would say the rare case that we would go to circuit court. So I'm gonna let Nicole step up now. One last thing I wanted to mention is, Michael or his staff, if they need to get on a property to be able to see what the violation is, they can seek an administrative search warrant. And what they do is they write up a search warrant, almost like if you're a police officer, you know, why we need to get onto the property. We need testimony from either Michael or somebody else of his staff. This is what I need to see. This is how I need to get on the property. And they take it to a judge and a judge says. So otherwise, we're restricted to how we can get on property, where we can be when we're inspecting. And all those things are legal parameters around how we perform our job that we cannot violate or essentially undercuts our ability to do what we want to do, right? So I will answer questions, but I'm gonna let Nicole take my place for a minute, and then both of us can sit over here and answer questions, I guess.
Hi, everybody. I hope you guys can hear me. Like Catherine said, my name is Nicole Essen. I do work for Buffalo Ball, in the up north office. I live locally up here, so I'm around easier to get to court areas for that. When we do enforcement actions, like Catherine said, our main goal is for compliance. There's two different avenues generally for zoning violations. And that's through the district court, the municipal civil infraction tickets, which again, Catherine went through. It's generally faster, generally gonna be cheaper for you guys, and you get the compliance order that you need. You can also go through the circuit court process. That process is a lot longer. It's a little bit more intensive, and that's why we only do it for certain situations. For example, if you had junk on property, like inoperable vehicles or garbage or trash, that would be most, in my mind, the most direct and easiest route for the municipality would be through the district court, because the district court is going to be faster, cheaper, and you're going to get that compliance order that you can get into, and the judge will say, okay, property owner, you have so long to clean that up. If you don't, the county can go on and clean it up for you. The way we go to circuit court for things are examples like if you're needing them to stop doing something, like they're trying to run a business out of their home, and they have like, I don't know, 10 cars parked there. It's not like a home-based business. With the zoning ordinance, they're commercial operations, things like that. It's not necessarily something that the county can go in and fix, you know. It's more saying you can stop, but the circuit court order is going to have a little bit more teeth to say, you guys need to stop that now. Okay. So that's the main difference between those two. What I generally like to see when we go through this process is I like to see the county staff or the municipal staff talk to the property owner, try to send letters, 1 or 2, sometimes 3, just get that communication going. So a lot of times if you get that communication going, you can resolve this issue. You get the defendants that don't want to communicate though, and that's when we have to write the tickets. When we do write the tickets, I ask for pictures of the property. In order to get those pictures, we can't go on the property without the property owner's permission. That's a no-go. No, not gonna happen. But you can stand on the roadway. Okay, you can ask neighbors if you can go on their property and take pictures of the neighboring property. But if the neighbors say no, you can't go on private property, period. End of sentence. Okay. The only way you can go on private property without the owner's permission is if you get the administrative search warrant. And in order to get the administrative search warrant, just like a normal warrant, you have to have probable cause. And in order to get that, you need to have an affidavit. You need to have that written up. You need to go in front of the judge or the magistrate to get that signed. Okay. I know our office will draft those up if we need to go that route. Most of the time, you can get the pictures from the roadway, the right of way, and we can go from there. You don't necessarily need to do that. There are some cases where it's going to be better to get on the property and do it that way though. So it's a case by case basis almost every time. So there is that. Like Catherine said, the municipal civil infractions are a lesser burden of proof for us. I know you guys were thinking about doing misdemeanors as at one point, back before they revised the Duplicate Act, state statute allowing us to do municipal civil infractions basically. Back before that was enacted, a lot of these were misdemeanors, but everybody, because that statute got revised, everybody has changed, kind of going over to the municipal civil infraction, just because it is easier, it is more cost effective, and you're not sending someone in jail, putting someone in jail for, having junk on their property, so you're not getting compliance. So I guess you ask yourself what the point of that would be. I mean, if your goal as the county is to have compliance with your ordinances, why put someone in jail because when they're in jail they can't comply with the ordinance. Okay? So think about that as well. Think
Yeah, so, I'll come back and we can answer questions together.
you guys have any questions so far?
I'm really concerned to talk about a lot of the infractions in county unemployed, young people building within setbacks to close to the river.
Yeah.
How's the county handle that?
So if you're within setbacks, too close to the river, anything like that, you can still go through the municipal civil infraction case, and then the judge would be, hopefully, so you get it to where when it's not completely built, but the judge can ask them to either move the building or take it down. That would be the compliance in order to get to the compliance of the zoning board.
And when we get a compliance order from the judge, okay, and the judge will say, in terms of a building that's too close to the property line, you either have to move it back or you need to tear it down within the next number of days. Or seek a variance, okay, that can be a possible option. You can seek a variance, you can tear it down, or one of these things within 60 days. They don't do it. So sometimes what we do is a motion to show cause, which means you are in contempt of this court's order. This court told you that within 60 days you have to do one of these three options. You did not do it. So what happens in our cases sometimes is if you go for contempt order, contempts have fines up to $7,500 a day, or criminal contempt, civil contempt, depending on which it is. The judge can put people in jail even for civil contempt. I had one case down by Coldwater, we're from Kalamazoo, where the guy was taking garbage waste from a tomato plant and just throwing it on property and next to people's houses and saying it was the Right to Farm Act. He was putting his farm product out on land. Well, we enforced that. We had MDR testify. The judge told him he had 60 days to get all that tomato waste off the property. He didn't do it. Okay, he was surprised. It's 100 degrees. We had to go out and walk through the tomato crap with the judge and the bailiff, and the judge said to the guy, this is off here by noon on Friday or you're going to jail. And I've never had a case go that far before. And it was Friday and we were all there. I was waiting for him to go to jail. And the judge said, we're going out again. This time I brought my boots, okay? I brought my butt boots. And we went out and he had made an attempt to clean up. He got about, 30% of it cleaned up. And the judge said, okay, you're not going to jail. I'm fining you for contempt. The fact that we had to come out here again, I'm fining you $5,000 for contempt, and you need to have it cleaned up by this day. So the heavy hand is once I have the court order, and this is, I can't say what your judges would do here. I don't know that, but in some cases, the judge will find you in contempt for violating their order. If the judge tells you on July 1st you have till September 1st to clean up and it's not done, and you go back on September 15th to court, the judge is like, why are you back here again? I thought I handled this. I told you to do this. Here's my court order. What did you not understand? And then the person makes some excuse about whatever situation is going on. And then we say, Judge, you made us spend county money to come back here again. We're wasting time. We're wasting money. He's in contempt of court. I want not only him fined, but I need this cleaned up or I need him to go to jail. And it's very rarely, never will they send someone to jail. Very rarely, once in my 25 years of doing this. But we got right to the minute where it almost happened. I was so excited. So, anyways, but what happens is once we have that court order, if they do not comply with it, we have the right to go on ourselves and effectuate compliance with tires or junk vehicles or whatever. or we have the right to ask the court to show cause. That might bring a motion to show cause, is why the court should not find them in contempt of court for violating the court's order. So that's the other way to go about it. So those are both options. Now I don't know your district court judge here or your magistrate. What we probably need to do is, depending on your direction to us, you're already at municipal civil infractions, is asked to meet with your court staff and see if we can understand lines of communication, how this might be effectuated. But would you talk about when you put someone on the stand, like the zoning enforcement officer or whatever, how that goes?
So when we're gathering the evidence, I guess, before we get to court, there's a lot of legwork that the staff is gonna do. Okay, not only the pictures that we're gonna need, but we're gonna need the certified deed to show the defendant actually owns the property. Because we actually have to write the ticket to the person who owns the property, owns or possesses the property. It's easier to have the deed there that says, yep, defendant owns the property, he's letting this happen, then he needs to clean up his property. The pictures, the ordinance that they're in violation of, whether it's the zoning ordinance, or the blight ordinance or anything, that'll be an exhibit as well for the court, so we can show the court, these are the sections that the ordinance states, that this is how he's in violation, or she's in violation. We would have the enforcement officer, the one who issued the tickets, on the stand. Probably, possibly Michael too, because he's the one that's been writing letters or anything like that, communication with the defendant. And then we'd ask those questions. There are certain things we have to do to each piece of evidence that we have to submit. So to get a piece of evidence admitted into court, so the judge can review it and actually look at it, you have to authenticate that piece of evidence. And there are certain questions we have to ask during that time. But that's kind of how the whole testimony thing works and how we get those evidence in. The pictures would be evidence, the deed, the ordinances, any letters that was written, any correspondence, that kind of thing. Would all be evidence that we could show the judge, saying, look, judge, this is what he's doing. We've tried to communicate with them 3 times, however many times we do, and nothing. That's why we're here. Now it's time for you to kind of tee it up and let us do our job so we can, enforce our ordinance.
That's essentially how it will work. Excellent. We really do not recommend changing. I know there's some discussion of after the 4th or 5th violation to change to misdemeanor. We don't recommend that. It's just almost an impossible task to achieve a misdemeanor. And so we don't recommend that. So maybe that's why we're here today to talk. I don't know. But we're happy to answer questions. And then, of course, the direction for enforcement, if you are urging more enforcement to your staff, the staff has to make sure that the county board of commissioners or whoever, that there's a budget for this, right? It's got to be in your budget. So, it's nice that we don't work for free. Okay, so, there's got to be a budget for enforcement. And then really what's important is that commitment to doing the enforcement. Because if we get right to the brink and then we back off, the word goes out in the community like they're never going to do anything. I can just do this, right? I had one recently where my township I've represented for like 15 years. They got a new board and they're like, why haven't we done anything about this junk car yard that has 100 cars over it over here? And it had been in existence for over 45 years. And so now this new board is like, we got to get this taken care of. We drive past it every day. Everybody hates it. And it took us like 2.5 years, but we got a court order, and the court order allowed them to take 2 years to get those, it was over 100 cars off their property. And they were removing them 25 cars every 3 months. Okay, so it's just been an enormous housekeeping task. My zoning officer has to go out there every quarter, look at the cars he removed, look at the titles of the cars that he sold or whatever. And he's been keeping up, but as it came and it's ending in October of this year, surprisingly, shockingly, there was a fire in like April and the whole thing burned up and there's burned up cars all over. And the man came into court and said, I should not have to comply with this court order to finish this by October because I had this huge fire. And you know what the judge said? I am so sick of you. Okay? And all of your various excuses and whatever. And he moved it up from October to September 15th. You guys got to get all of it. And they're just mangled and, burnt up and everything. So obviously, if he doesn't finish by September 15th, we show cause him as to why he's not, why the court should not find him in contempt. And I think if we go back again, the judge is going to fine him. But, there's cases, and all of you can probably think of one in your area, where people will have junk or junk cars or litter or building materials or something they've had on their property for years. And, that may be valuable to them, or for some reason they may care about that. But if it violates your ordinance and you want to enforce it, you start off with whatever process Michael or his staff already use. We're going to follow that process to the T. We're not going to screw it up by going on the property and here, no drones, no drones. Okay. There's case law that's already been gone up to the Michigan Supreme Court, and it may go further, but no drones for zoning enforcement at this moment until we get some court decisions that say yes. So we're limited to how we can get on the property or observe the violations. As Nicole mentioned, if we need to get on the property, we're going to do administrative search warrant, because then nobody's going to question us. If we mess up on how we do the process, we've thrown the case out the window. So let's not mess up on how we get our pictures, because then we've just, it's futile. Okay, we'd have to start all over again. We may get into court and the judge may throw it out because we trespassed on our properties. So keep that in mind. So we have to do it right while we're doing it. So we're happy to answer any questions you have for us. I don't know how much enforcement has been done over the years. Michael can tell us. Okay, yes, Mr. Freeze?
On a lot of these are waterfront problems, setbacks from water. Is there any reason why we can't use a boat?
No,
You could use a boat. So the lakes and rivers, they're navigable. That's public right of way. You can be on a boat and take pictures from the boat. You can't dock and step onto the dock or anything. You can be out in the lake and take pictures.
Go right up to the ordinary high water mark.
Yeah, unless there's some type of private channel or something. Yeah.
You can only be in the public navigable portion of the lake. So
navigable is right. You have to be able to move through the water.
Move through the water freely.
So,
and so it's better to kind of stay back from the property. So where the boat traffic is, that would be the best way. So so we're not arguing about whether you were on
their property or not without permission.
It's better not to argue about that in court, like Catherine said, because then that's going to get the judge thinking off topic and constitutional issues that we don't want to have to be. So when you're on the boat, I would stay within the towards the away from the docks, and you can take pictures with today's cameras. You can zoom in and take pictures of the structures that are near the waterways.
Make sure your pictures have dates on it. When you take the pictures, you have to date the pictures.
Date the picture, right? Or when you put them on the computer, save the date that you took them, because you're gonna have whoever took them is gonna testify that on that date that picture is what they saw. So
Can you use a laser to determine distances?
no, I would not do that. If you want to measure, we'll get an administrative search warrant, and then we can go on the property to measure. So.
Can you use something like Google Earth to see what's in the back of some of these properties?
Well, you can, but then the problem is
that we can't use that.
Can't authenticate it. We have to get somebody from Google.
Yeah.
To come here and be on the stand and say, yes, this.
You can use that to try and get some probable cause.
So you could possibly get an administrative search warrant.
Yeah.
Based off of that.
Yes.
Google Earth's pictures.
Yeah.
Yes, sir.
Seeing this is the method of enforcement. Now talking about the civil.
Well, I believe so.
Yeah.
I just don't know how it's been handled so far.
So I think that it's going to boil down to these fellas don't have enough help now. We have hundreds of violations, not just a few, and they're not the easy ones that you're talking about with the junk cars and building materials. These are people that have commercial
Right.
contractors' yards, and they don't have 10 acres, they don't live there, these are campgrounds that people are
So
using, that they don't meet the standard, there's setbacks, there's houses going in. And how often do we see judges tear someone's house down because they're 10 foot closer to the wall?
sometimes they do.
Do you know any
I do,
in our area?
I do,
In,
it was a full round.
but I mean, I've been looked at a lot of research, and that doesn't happen very often.
Well,
They usually get a variance. or
That's the
something.
thing, yeah, they may get a variance. Thing is, you go back to how much does this county want to throw in enforcement? Okay, that's the point. Do they want to put money and devote money to this?
So, what my understanding is we used to have an enforcement officer, so that was a line item at some point that just kind of disappeared,
I don't know.
died or something, but the money was there.
Right,
And we have sent numerous letters to the board of commissioners trying to get some help. They can't look at all those violations.
no,
They can't follow up on it. So what we're doing now is not working. I think all of us agree. It comes up at every meeting or every other meeting. And we thought maybe there'd be a new twist to it, but it sounds like whatever we do is time consuming.
no, but this is
Yes.
municipal civil is 1,000 times easier than this.
Yes.
Do you understand what a jury trial is? I mean, my gosh.
Any enforcement is going to be time consuming from the staff's perspective, right? Okay, it's gonna take time, it's gonna take effort, and so if the planning and zoning department need more people to do that, then that's what the county needs to look at. The Catherine's right, civil and municipal civil infractions are gonna be less time consuming than the civil misdemeanor trial or even a circuit court case.
Yeah.
But
Yes.
Um, we've got a number of problems, and one of the things we've objected to and tried to get additional help as far as enforcement goes. We come through and we look at these things that come through and get an SUP in front of us. We approve it with 5 conditions, 10 conditions, whatever it is. And we have nobody that is able to enforce those.
Do you want to revoke it? Do you want to revoke the special use?
That it's to the point where I don't think it does any good to put conditions on one. We can't enforce it.
That's a fair point, but
I think that goes back to staff issues. If you need more staff, because if you have conditions on a special use permit, then that if they're not meeting those conditions, then that's a violation of the special use permit. You can revoke it, or you can go through the court process as well.
so the quickest way there is to go with our special use. Okay, and so obviously, so a special use is sort of quasi like a property, right? You can't revoke it without notice and opportunity to be heard. Okay, so we have to give them notice. So we have to say we're gonna have a hearing on this at our PC meeting on such and such date. You have the right to be present, etc. But we can revoke. Now,
Can you give us a quick and dirty written set of instructions, procedures
Yeah.
that we can follow? Because
Yeah.
that may be the way to.
well, so
Yeah,
then
that's-
let's say we revoke and they keep doing it. Okay, so now we're still in a zoning violation, but we're in a much better, stronger position than us letting it go on and doing nothing, right?
Right.
Because then we go and write a violation. Now you're in violation. You're running a business in your home. You had a special use approval. It was revoked because you failed to meet conditions. Now we go in front of a judge and say, Judge, they had permission. They didn't comply with it. They got a letter or two from Michael, and then we went to revoke because a special use permit is almost like a contractual agreement, right? You got this approval. We made findings that you got this approval because you met certain standards. But those standards require you to meet these conditions. You fail to satisfy the conditions. We're going to revoke your special use. And, some people might say, okay, who cares? Nobody ever does anything around here. We have to take the first one. We have to follow through on one. You have to get a court order. You have to go out and enforce it. And let's say it's somebody running a business from their home. We revoke the special use permit. Now they're still doing it. Now we write citations. Now we go into court. Now we get a compliance order. On that one, we might even go to circuit court. We might go to circuit court because it's that serious. Okay? And then we get a court order from the circuit court judge and joining them, which means you may not operate a business on your own. Okay? And that's a case where I probably would go to circuit court if we revoked a special use permit. So understand there's ways to do this, but if the municipality, county in this case, does not follow through on one of these and make a, you know, you gotta the shot heard around the world. It's gotta happen, right? If it doesn't happen, nobody believes it will happen.
And unfortunately, it's gonna cost the county money. Yeah, any of these options is gonna cost money. You can recoup some of that cost, you know, once we get the court orders and but it's not gonna be, it's not gonna be given, it's not gonna cover everything. It's not gonna cover all of our time, it's not gonna cover all of the staff's time. But that's the nature of having ordinances and enforcing them. So you just wanna make sure that you understand that you're gonna need to have a budget item for it.
I called around Northern Michigan trying to find out other counties, just how they choose their enforcement. A lot of them don't have very much like you do, but Traverse City, to my understanding, they have a fining structure put in place. So the first fine is there's a letter with $150 fine. The next month is a $250, and the third month is $500 with the court appointment. Is that civil still, or is
that
criminal?
could be civil, but we don't necessarily want money, right? I mean,
We want to cover our expenses.
well, okay, but the bigger goal. So you know, maybe we have to look at if they have an ordinance that is a fine for following and that type of thing. And there probably does municipal civil, I guess, but I want to think, yeah, and I have to qualify everything I'm saying again. Is we have to figure out how to work with your district court here, okay, so that they understand that we are able to communicate why we don't just want you to find people, we want you to find them in violation, give us a compliance order, and then let us enforce that compliance order through show cause motion or whatever.
And you wanna be careful with having ordinances like that with fines, because some judges will look at that and say, nope, it's a fine, pay it and go. So you're not getting the compliance that you're wanting. So, I mean, you can fine them all day long, but then that's just costly business for them. You know, it's
So if you're short-term rental, and your short-term rental, we in our township are no short-term rentals, and they're making 10,000 a week on a short-term rental. Do you think they care about paying $100 fine or $250 fine or $500 fine? They don't care. So we have to go about it another way to achieve compliance versus money. Yes, John.
I've been in this a few years, like maybe 40 some now. When I started, we didn't have an outside counsel. We had our own counsel here in Dover. We could never get them to do anything. We refer something to them, we can forget. So what was it, 45 years ago that we went to an outside counsel? Maybe 30. And now we're paying for your time, and we could get some action. But I am concerned with having a new judge, just what his perspective is, and I would like to see him get together with his staff and find out what his thinking is.
Yes, I think that's a good idea. I would like to do that. And generally, when I go into a new county court system, I do that. Now, especially that we know there's been some challenges here with enforcement. Nicole and I were asked to meet with the judge's staff, the court staff, people that take the cases in and process citations. You know, we had a terrible 2-year-long struggle with Cheboygan County, which is down in They would not do municipal civil infractions. They would not issue compliance orders. And we ultimately had to go around and go to the county board of commissioners and say, hey, we need help. And then the county board of commissioners came back to the judge's staff. Then stuff moved. You know, we don't like to do that. We don't like to do that. And I'm not saying I will do that, but I need to talk to your judges. So please don't believe that's what I'm saying. Okay, I don't want to manage.
I'm just anticipating.
Whatever
You touch it right.
Well, hopefully not, right? This is something that a lot of judges aren't really versed in zoning, planning, drug enforcement. I mean, we do this all the time. So we have 3 attorneys in our office, in addition to Nicole, that just basically prosecutions for light and zoning, ordinance enforcement essentially. So if she's ever unavailable, I'm unavailable, I'm gonna send another attorney up here and handle your cases. But the bigger issue is, we'll talk to the court staff, we'll talk to the judges. There has to be a commitment from the municipality, from the county, that we think this is important and we're going to follow through. Yes, sir.
I think that's the way to move. I think that the board of commissioners or a member to be involved in that meeting. Mike and Chris should be involved at it. You have a member from the planning commission just to sit and see what they have to say. I think that's really important for number one. And number two, we need some help getting another enforcement person because we have all kinds of special use permits over the last 20 years. Nobody ever gets a chance to look at them. Once they leave here, most of them do what they want to do. And they don't have time to review each one of those on a 5-year basis or something. I worked for the health department for a long time. And what we did with food service and so on, when those were due for evaluation, we got a computer printout that says you got to look at these. It's been 5 years. So you knew what you had to do that week or whatever, you could cross them off. And they don't have enough staff to talk to the people here. So I think, the big thing is getting some help. They're interested in enforcement. We can't do it. They can't do it. We need someone. And we did have an enforcement officer that cleaned up what percent, 50%. Like, I mean, he had a fantastic, success for a while. The fellow that died. Yeah. I mean, he did a great job. And I think a lot of those can be knocked off by contacting them. And the other question I had is that return receipt letters, or do you just send one out so we know if they got it?
Generally, we just send them out.
Yeah, or they just say they didn't get it. We did all return receipts. And then you have it, if they don't pick it up and they were noticed for it, then they're responsible that they should have picked it up. I think that would help.
If you want to do that, you can dodge those.
But if they dodge them, it's a it's them getting it and not, it's
Yeah.
what our attorney does.
With the court, for service and stuff, putting it in the first class, having the correct postage and putting it in the receptacle for the postage at the post office is the same thing. As long as you have the last known address or the address on the tax roll for that person, then we don't have an issue with the courts. And defendants will say, oh no, we didn't get that. Like, no, I sent it first class mail at the
Estate
at the last known address on the tax roll. This is how I'm supposed to do it under the statute and under the court.
Well, we can do whatever you want, but
I just think if you got a letter in your home, just a letter in a mailbox, you say, you got a return receipt letter that you had to sign for or whatever, things change. Whether it's court wise or not, in people's mind, they know something's happening. I totally agree with you. The ones we take to task, we want to know one through the community that you mean business finally. But to do that, again, it all boils down to the county wanting to provide some help to these folks. We send letters. We could use some help from you on how to do that. Maybe some comments from you once you look at what's out there. You can say, hey, we can't do it.
like once a year with the board of commissioners.
Just like set up a meeting.
Okay.
We've done it twice in the last 25 years.
Well, we did one a year and a half ago, yeah.
I think, okay, I'm already hearing it in my neighborhood. Nobody's doing anything. We had one guy put in something that wasn't supposed to be there, and the neighbor said, that way you go, and said, I was told that we have something that sounds stuck anyway. See, that happens all the time, every day,
The county's a free for all, and everybody knows it. And if I may, to your point of follow through, we have followed through on several, if you will, high profile violations. However, in my humble opinion, there hasn't been enough of that follow through to sort of get the word out in the community.
We don't have the time to have more than a couple willing.
And to the discussion about how we mail notices violation of their standard mail certified, we send 95% of our notices of violation certified.
Right.
So you get a return each season.
Yeah, I think that's important.
You know, documentation,
That's
someone signed for it. It does cost the county more in postage, but as you pointed out, Mike, someone could, if you just send it regular standard mail,
You know,
they
all
can
the
say, well, I never received it. At least we have some documentation to the certified mail process.
I think it would be helpful, other than just us as new attorneys in town, to have somebody from the county, whether it's the county manager, whether it's certainly Michael and his staff, a county commissioner, somebody from your, to go and ask to meet with the court staff. So we can just explain, how we would like to proceed on these things and why it's important that we get compliance orders versus fines. So I don't know how to set that up. I don't know how to arrange that. I don't know if someone at the county could take the lead on that, reaching out to the, district court. If you want me to, we can reach out. They just don't know who I am at all.
I think it would be important for you to reach out and
Okay.
include these folks, maybe
Propose a
someone.
meeting.
Yeah, propose a
Okay.
meeting, because they're gonna listen to you and you're paid for by them. I think it'd be important, even though you probably don't wanna do that, I think it's important
I will.
to do that, and maybe, you'll get a chance to talk to the commissioner that's there and say, hey, the problem is they need help, they're willing to do it, well, that's where it is. That's the barrier.
We can do that. I'll just say, in our practice throughout the state, we're very successful with this procedure with the municipal civil infractions. Very successful. But every county has a little bit different process they want us to get when we come into a new county. So I know it will work for this county if we can establish lines of communication about what we're trying to achieve and what they have the lawful authority to do, and we're not asking you to do anything you don't have the lawful authority to do, and here's how it works, and that type of thing, and hopefully we can have that conversation. And then the bigger part though is the commitment to the county budget wise, and understanding why this is important. Okay, understanding why this is important so that people aren't out in the county saying, I'm just gonna go wherever I want, nobody's gonna stop me. Okay? And if there's no fear of that, then why even have zoning at all? Okay? Either you're gonna force it if you have, or you're gonna not. And when you're in that, kind of a half pregnant state, it's not good, because people who do the right thing and rely on it are then angry when other people don't have to follow it, right? And it's unfair. So, but every municipality has a different approach to how important it is, right? Some are like really rigorous, cities, like you say, Traverse City or other cities, everything is very rigorously enforced. They have the money, they have staff, they have the time, they've prioritized it. I have small townships that have no zoning at all. Okay, so if you're going to have it and you want it to be enforced, we have to make a commitment to that, and we have to continue that commitment. We can't just do it for a year or two and then drop off, right? We have to continue it. Yes, sir.
I agree with you totally. But I think there's, in addition to having a meeting with the judge's staff, I think it's going to be imperative that you get across to our county administrative staff that it's liable to cost them some bucks.
That's why I'm asking, do they have the same priorities as you?
That
I
don't
answer that.
think they do, personally,
So,
because they're not willing to foot the bill for an enforcement officer.
right.
They say, well, the duties can be spread around several people in several different offices.
And so I'm, obviously, I don't know if the planning commission, through their minutes from today or something, wants to stress to the county board of commissioners how important you all this is.
We put it in county
There's several
on
others.
several
I've
occasions.
spoken to them personally, or
Okay.
a couple board asking for enforcement. They're all well aware of it needs enforcement.
And there are some commissioners that are on board with that, correct?
Correct. And there are some that want no enforcement.
Right.
If some don't want anything.
Well, and maybe you need to have them come to a neighborhood. Maybe whoever's your county commissioner, your neighborhood association needs to invite them down and say, look, I want you to walk around here with me. and I wanted to see what I'm talking about. You know, I don't know how else really to skin that cat, because we can do all of this. You can talk to the judge, you can discuss your, you know, understanding how we move forward. But if there's no money to do it,
And if I county commissioner, we have person to allow for another, enforcement officer.
Is this board state mandated county? Plus it's board
yeah,
state.
if you have zoning, yes, you need to have a planning commission. If you have zoning, you're supposed to enforce it. The question is, how rigorously are you going to enforce it? How closely are you going to enforce it? How much money do you allocate towards enforcement? That's a decision of a legislative body that's about you, right?
So the allocating the money to enforce the zoning ordinance is a county commissioner board decision.
So it's not really dictated by the state, like technically you have to have us. No enforcement officers included in that.
No, in the zoning enabling act, it will talk about if you have zoning, you know, there are certain things that need to be in your zoning ordinance, and one of that is enforcement. But there is nothing that says you must enforce every single violation. You must only, you know, you can enforce every fourth violation. I will tell you, there is the concept of selective enforcement, where some townships or cities or really smaller places will operate on a complaint basis only. We only go out in response to complaints that we get. And that's because they don't have the money to do a routine survey of their municipality all the time. And the argument, an affirmative defense is selective enforcement, like, hey, you're picking on me and there's 87 people over here that you never got to. And sometimes that can be used as a defense against a zoning enforcement violation. But they'd have to prove that you had purposely singled them out in some type of nefarious way, versus all the others. But I have seen it used before. So it's a difficult thing. Money is a component in almost every municipality we deal with in terms of enforcement. I represent a city of 50,000 people. They have 10 people in their planning department. They can enforce. Okay. If you don't have that ability, you don't have that money, you have to make decisions how this is all going to shake out, essentially. But obviously we're happy, we're willing to contact the court staff, see if we can set up a meeting. And if we do, I'm going to ask Michael to get, one or two of you, as well as hopefully maybe a county commissioner and county administration to come with us. So we can maybe make some headway. Yes, sir.
Is there any examples of any municipality that ever took we're countywide zoning except one county?
Mhm.
Has any of those townships ever taken the county to task for non-enforcement? Has there been any litigation of that type?
I've had townships pull out of county zoning when they feel that it is not representing their interests. I have not personally had, or in my firm, I'm not aware of a township suing the county for failure to enforce. I do have had, especially in southern Michigan, where we have a lot of renewable projects, solar, battery storage, all that. I've had like 3 or 4 townships in the last year who feel that the county isn't adequately representing their interests when they approve large solar projects or other projects, and they pulled out and started their own zoning. That's a costly endeavor, because you have to do a master plan, you have to do a zoning ordinance, and then you have to enforce. So, that's the question for a township if they want to go that way. But I've not heard of anyone being sued. Doesn't mean it hasn't happened. Yes, ma'am.
It just occurs to me that I think we probably need to get our county so that we get where the place where the problems are, and then we can educate the commissioners plus ourselves at what's going on and develop a relationship where we can communicate what needs to be done. And when you have enforcement and follow through on it, then things will change. But until we know what the importance of each township is, it might not be the same in every township.
So like that.
And when, I go to a township, I don't know anything about that township, so I need to be educated about the township. And that might be true in some of the people that are on the county commission or on the, county.
I know the county commissioners go out to the township board meetings in their districts. So I mean, obviously, if these are issues in a particular township, it needs to bubble up,
Yes.
right?
I just think it sounds to me like there's a bit of a lack of communication. But I think also that it would help if we put our heads together in formulating a plan that we use with everyone. You know, how we go about doing it, so that they realize that yes, we want to help, and yes, we want to see if we can fix this situation.
I think some of the township supervisors are already working closely
Oh,
with
yes.
Mike, but
Yes, some are, but I don't know if all of them are.
they're not.
Yes.
And then, Mr. Chair, if I may recall that in 2022, there was an ordinance adopted with 11 township signatories to allow for the sheriff's department to help abate blight. We don't have the county level authority to abate blight. We apparently have authority to abate junk unlicensed vehicle, which is an element of blight. But you know that, and then Catherine, you suggested maybe taking an elected official or two out. You know, blight to me is the most obvious, and arguably the one element, if you will, of enforcement that can have the most negative impact on a community in terms of encouraging
So if the
investment. But you know, as has been pointed out, we have myriad zoning violations that include operating a business without a special use permit, building a pole building without a zoning permit. Those are violations that are egregious to the eye, per se.
Yeah.
Like blight, in which we don't have a lot of
So
authority.
if the sheriff does blight, who prosecutes? Who does the court stuff for that?
Yeah,
I can't speak for the other 11 because Esquire has their own like ordinance. So it's our police department. Here, it's our attorney.
Okay. That's what I'm hearing.
Is it the prosecutor that does it for the girl?
Yeah.
that's my understanding. I haven't been privy
Why would
to
the prosecutor do
the process, however, because the townships work with the sheriff's department to investigate and attempt to evade, identify blight.
It could be the each township's civil attorney that does that.
Must be, it's not us.
I don't see how a prosecutor could do that, it'll be a civil case.
Because they're police power or
No, but unless it's a misdemeanor,
unless it's a misdemeanor.
why would we do that? Okay, well, that's not our issue today, so.
But it sounds bad. Does the police, the sheriff, and he changes for these cases or?
Well, so fear enforcement ordinance, the sheriff's department can now use patient tickets for that. And then, so I've worked with police departments before, or municipalities that are doing their ordinance violations. The police department would then issue that ticket, but then us as civil counsel would go through the court process with them, not the county prosecutor. Right? If the county prosecutor is inundated with misdemeanors, felonies, all of that stuff.
So does that help us if we have the sheriff's department issue tickets? Would that help us somewhat with enforcement?
And so that's he's talking about blight.
I'm talking about.
She's talking about zoning.
I want to see if
Can you use them to do some zoning enforcement as well? I don't know.
Well, although we've been offered help in that regard, it's been suggested that we use Catherine our firm to help with the writing of tickets. And you know, we have in the past, I have tapped into Peter Wendling's expertise when I've written tickets. So I think we can continue that pattern of using legal counsel.
Yeah. So what could happen is when you have an ordinance or zoning ordinance, in these sections it'll be enforcement. There's a section called enforcement, and that'll dictate who the enforcement officer is. Sometimes it'll just say enforcement officer, sometimes it'll say sheriff's department, zoning administrator, you know, and anybody else the county commissioners have deemed appropriate. Okay, so you could have the sheriff's department help enforce that. If they are to do that, because this is a municipal civil infraction ticket, not a civil infraction like a speeding ticket, so it's going to be slightly different. I would still have the deputy talk to us before he issues that ticket. But he can certainly have that to be enforced.
And I would add that, the sheriff's department to date has been quite helpful in terms of accompanying us to particular sites, based on our schedule. You need to do when to do it. So I suspect that will continue given my discussions with current Sheriff Ross. So you brought up something that just reminded me of a question I want to pose. It sounds like given this discussion that what you really need to memorialize process either in the ordinance or as a separate sort of policy document that perhaps would be an addendum to the ordinance, because as it currently stands, we don't have clear guidelines.
So what you can do in that aspect is you can the county commissioners, their legislative body, can adopt a policy on how enforcement of ordinances can take effect. And you don't have to have that as an addendum or an amendment. In fact, I would highly suggest against that, because that way you can change that policy if it needs to be changed, so it can be workable for your office.
So
you can draft the policy and they can adopt it, and then that will give your office guidance saying, okay, I have to do 3 letters before I can write a ticket, or 2 letters, or I have to contact them how many times. A lot of places have policies like that.
So an enforcement, it's like I have a very rough draft of an enforcement policy manual, so I doubt that. That really is something that would represent what you are suggesting in terms of a policy. It doesn't have to be just a 1 or 2 page document. It can actually be a manual, because what I have as far as really voluminous, I don't know if it can be one of the, obviously I would have legal counsel review it, but
I would caution against having a policy that's too long, too big, because that can. The bigger the policy, the more loopholes you get. The more
If you miss one step,
right.
So you want it flexible. 1 or 2 pages. You want it short, simple, so anybody who reads it, because if the general public is going to ask questions about it, you want to make sure that they're going to be able to read it and understand it and see how you enforce things. So you don't want it to be too tight, too big. You want it 1 or 2 pages at most.
But it makes my life a little easier.
But that way then you can rely on it. If you or your staff can say, okay, we followed the policy. We sent 2 letters. Now we write a citation. No one can come back and say to us we were unfair and treated differently than anyone else, right? Right. Any other questions? Yes.
I both agree. Is there a way you can put a procedure together for us to revoke a special use permit that has
Yes.
come up?
Yes.
Would sure appreciate.
Yeah.
Take time to look at that. Thank you.
Yeah.
Nice.
Okay. And we'll probably have to have a public hearing on revoking. Yes, public hearing on revoking. So if you want to do a bunch of them and have a big Saturday public hearing, if you do one in one time, we'll have that.
Oh,
Thank you for your share.
Thank you. Item 2 on our agenda, discussion regarding establish a case work with the renewable energy.
Thank you, Mr. Chairman. This is the official, if you will, initial discussion about perhaps drafting a affordable renewable energy ordinance and replacing our adopted CREO, the compatible renewable energy ordinance, so I think it's amendment 186. And someone question.
Before we get into it too far, I went through and came up with a draft of the workable one until we got a package last Friday with a half-inch thick guidance. So I'm rewriting the whole thing again based on this.
Yep.
And I should have it ready about the first of the week. But I also, since we were looking at solar, and since we really have to look at three things, we have to look at energy and we have to look at wind. I get the same half-inch thick packet for energy, the battery.
Battery energy storage system.
And I've got that one done. I gotta get it tight. I've got to get the same thing on wind.
Well,
I'm sure another half-inch thick packet on that someplace.
and staff has some language too that we'll have to look at integrating the draft.
You can have my draft and then you can add yours to it.
But all I'm going to do here, I'm going to, attempt to be brief, by comparing the pros and cons of our current Creo to a possible workable ordinance. And really what it comes down to, and obviously, Catherine, Nicole jump in, especially if I'm off base here, but what the workable renewable energy ordinance would do for us is it would allow us to impose standards or requirements that are beyond what are required in PA 253 by the Michigan Public Service Commission. The downside, it's a bit of a gamble because with a CREO, that is a guarantee that the local unit of government reviews the application and site plan for a renewable energy project. Now, a workable ordinance does the same, a workable renewable energy ordinance, but the significant downside to that, at least in my mind, is there's no guarantee that a prospective developer wouldn't go directly to the MPSC and bypass the local requirements altogether. So I don't see the need necessary to belabor these slides. I've got 4 or 5 slides here. We went over a lot of this material last fall, just before we adopted our CREO, which was adopted by the board in January of this year. But again, disadvantages of the CREO, which is what again we have now. There's really no opportunity to have local requirements that are considered stricter than what is in PA 233. We've talked about this recently in several recent meetings, of course. And then another disadvantage of a CREO is if a local unit drags their feet beyond the 120-day window, although that is negotiable, you may be subject to fines. That's an unlikelihood in my mind that if you were to get another application, it would drag out beyond 120 days. But that's one potential drawback of having a CREO. So with a workable renewable energy ordinance, again, the government would maintain local oversight, just like with our current CREO, but there's more power for negotiating with the applicant for additional standards, such as screening, because screening, as you very well know, is considered a stricter standard, if you will. It's not required under BA 233. Again, I don't see the need to belabor it. We talked about that quite a bit during our last meeting at the Opera House. So, the potential downside is we have to sort of hammer out what it is we want in our workable ordinance. Now, one option I can see off the top of my head is simply using what we already have adopted in 1730 zoning ordinance, which is our solar energy ordinance. As well, though, that is pretty long in the tooth. That was adopted. Back in
I
20
wrote it
years
about 7 years ago.
Um,
And I might add that the solar energy facility that we just proved went along with everything but about two things in that original ordinance. One of which was the screening along highways. Well, I forgot what the other one was, but it wasn't. It could have been. We could have taken the regulation we had and call it workable, and changed two things in it or three things in it, and they lived with it. They were happy with it.
If they decide to go with the work, is that something they agree to? And could they come before us and say, hey, you guys are too tough, we're going directly to the state?
yes.
Okay,
So
so,
what's workable to one developer may not be workable to another developer.
so even though they accept going through the process with us, if we were too tough with they just go somewhere else, so.
That's the gamble with a
Yeah.
workable ordinance.
But it may be worthwhile,
I just want to say, I personally have 6 projects going on right now in my practice, and in my practice, probably 30. Not want to go to the state. I have the largest solar project in the state right now that I did is 8,000 acres, 800 megawatts by Marshall, Michigan. They do not want to go to the state. I have one project where my township's been in a moratorium since this January, figuring out about battery storage. It's a 400 megawatt battery storage, and the site they picked is next to an elementary school that's under construction. So the township is like, no way is this happening. We are going to put a moratorium on what we get a workable ordinance. We're putting a moratorium on it, and we're going back to the drawing board to figure out what kind of setbacks we need from what we're calling sensitive land uses, hospitals, schools. And you can do that in a workable ordinance. You can't do it in Rio. Okay. So I think just in my personal experience and the experience of our firm, and I have one partner that's probably got 15 projects going because GTE recommends him to any municipality to walk into. Nobody, I think the risk is low for anybody to go to MPSC. Now, over time, that may change if the MPSC, the first case for the MPSC was submitted in May or June, and they wrote a very rigorous, thorough response letter to the developer that requires a lot more information. Okay, so, but Michael's right. This is kind of a gamble. If they don't like your ordinance, if they think it's too tough, they'll go to the state. But with the reviews I'm seeing coming out of the state right now, they don't want to go to the state. Okay, so we have to figure out, where does the rubber hit the road? What are we willing to put out there that we want? We want more than $2,000 a megawatt because you can get it at the state. If you want to come through us, to be faster, cheaper. We want 2,500 megawatts or more. Okay, my law partner is getting more. Okay, we want a decommissioning agreement. We want landscaping. We want that the decommissioning amount is reviewed every 3 to 5 years and it's upgraded every time. We are not taking your salvage value. Law say allows you to subtract out salvage value of their panels, for instance, from the amount of money they have to post with you as a decommissioning. And we say, well, I represent a lot of rural townships. Township does not want to go in 30 years and scrap the damn panels and get money for it to be made whole, right? So we don't take salvage value in our workable ordinances. They have to pay us all the money up front. Okay, so there's a lot of things we've learned over the last few years. If you do want to go to a workable ordinance, we can provide some input on that. But I don't think you necessarily have to be scared about going to a workable ordinance that, because what most of my clients feel is the CREO limits you so much and what you can look at in a project. It's very limiting to exercising your authority, and you may not feel comfortable approving the project and within those limits. That's what a CREO does. It's very limited what you can look at, and if the company meets those standards, you must approve it, as we just saw, right? So that's something to think about. It's not a perfect situation, but it's certainly something you might want to look at exploring.
What's the status of the bills that are introduced to get municipalities back to having oversight of these big projects?
Okay, so, as a general counsel for the Michigan Townships Association, we are kept updated on legislation like almost weekly. One of those bills is in the House, which is Republican controlled, probably gonna go through. The other bill is in the Senate, which is Democratically controlled, probably will not go through. So it's almost like a stick, I've heard it could be a stalemate. Okay, then the other thing is what's happening with the litigation that many municipalities brought in. Yes, there's pending litigation in the Court of Appeals in Michigan. Was something when they filed, it's more now. Municipalities sued the Michigan Public Service Commission about their order about how they're going to apply Public Act 233. That's at the Michigan Court of Appeals. Don't know when it's going to move, but all that does is if municipalities win, the court will order the MPSC to change how they implement Public Act 233. It's not going to do away with Public Act 233. So Public Act 233 will still be there, just how the MPSC implements it or how their process could be changed by that language. Okay, so this is kind of a very fluid area of the law right now. With the push for more and more renewable energy, we're just seeing projects, especially in Lower Michigan where our other offices, it's just explosive. So, so that's for what it's worth. That's what we can, contribute to the conversation, and I'm happy to answer any questions.
Yeah, this slide I pulled up a few minutes ago. Fills the conflict. Catherine said about why developers generally prefer local permit. It's basically they save time and they save money. Going that route as opposed to the MPSC. I have heard recently that the MPSC has received their first applications, handful out.
They got a couple of them. One was from Ranger Power. It was in just south of Lansing, 3 townships. And if you go on the MPSC site, all the cases have a number, view, whatever. You can find that case. And there's at least a 10-page list of requirements that the MPSC found were not satisfied. I mean, really rigorous review, much more than like you or I need to. So we know the MPSC is going to be tough on these reviews. I personally serve on I'm a consultant to the Graham Sustainability Institute of the University of Michigan, which is one of the 4 leading groups in the state on this matter. I consult with them every other week. And there's also a person on the other side who's from the industry. And both of us said we cannot live without help the MPSC on this vision. So whether or not that tapers off, I don't know. But it was very interesting to see how hard they came out of the box on their first application.
So with that, if there are any questions, additional questions? Well, G is a motion and all that whether to move forward with drafting a workable ordinance for future review and consideration.
To make a motion, we go forward with doing it since I'm 2/3 of the way through it.
Motion and support to look into the feasibility of writing ordinance, workable renewable energy ordinance. Any discussion? Any further discussion is what we could say.
So you're saying that if we go with the workable legislation, we have more flexibility to negotiate with the companies.
Yeah, you still have to have an ordinance. There'll be standards in there, like you have to have screening this wide and this many trees. And, you have to post a decommissioning bond, financial surety, and we like to have an agreement for that. We like to have an agreement for vegetation maintenance, so if the trees die or whatever. So a lot of times these companies are built by a developer and then it flips over almost immediately or very shortly thereafter to another company, maybe Consumers Energy, maybe DTE, maybe somebody else, okay? So we want to make sure, just as you talked about earlier, that your special use conditions, the obligations are also going to follow to the next person. So we reduce things to agreements. So you have more flexibility. I'm not saying you can just, it's not all negotiation. Your ordinance that you draft, whatever it is, will have standards in there, but it will be more than what's in the state law. Okay?
You can find that way. Consumer power there. We're here and they are coming in, what do they call it? It's 50,000 acres. We can't hear you. We cannot hear you.
Our proposal would expand their portfolio considerably to include renewable energy.
Oh, I know, the fair there is way over there. So that works real well.
Now it doesn't work.
So that is
Probably wouldn't work anyway, so what's the point?
okay.
Just project on if you can.
Okay.
There are empty seats in the front row too.
We have people that are hard of hearing here, so I don't think that's gonna help. Maybe we can get some microphones that work with a new one.
Oh, you
So
can
people
try.
can hear. Something
How much money have we put into the microphone system in this building?
Hi.
Aye. Any opposed? Motion carried.
Mr. Freeze has a question. I just wanted to mention the fact that I'd gone through the solar. And as I said, I had a draft ready to go until I got this document from the University of Michigan. But then I got a hold of the battery material. And there's actually some things in there that they didn't have in their solar. One of them is in relation to the sound requirements. And the battery one has a post-construction survey that has a requirement that they go out and get somebody that goes out and checks the actual sound levels after the thing is in operation. And that's something that they didn't even cover in the solar, which is going to be in there now when I rewrite it. But interesting.
That's approved.
Any general comments? Any comments before we play here? I'd like to make a motion, I don't know if this is the right time or not, that when someone comes before this board because of a violation, we issue no further permitting until they're in compliance.
And I asked you folks, is that a legal?
Well, that can be difficult because if somebody's in violation, so if somebody's in violation on property A and they want to do something on property B, it's very hard to prevent them from moving forward with their rights on property B if something's wrong on property A. So that's a great idea. I don't really think it's lawful. I know there's under law, there's some provisions for cities and villages that if you're defaulted on taxes or anything like that, you can't get any permits. I don't think that extends to counties and townships, but I can live with it. Okay. But that's more of a default on like property taxes or fees owed to the city, that type of thing. It's not a violation. It's on. But you know, because under law, no, it's a great idea. I just have to figure out if there's some way we could tweak it.
Like this is what we can bring it up with, like, we approved the focus of it for its facility, and they wanted to build something else on the property in addition.
Same property, somebody's talking about an additional, on that property that's a violation.
Sometimes, so yes, in that particular case, it's gonna be you bring your whole property in compliance when you do nothing, right? So, you know, obviously in that case, I don't know what you have to do to bring that first building into compliance. Either it's, and so sometimes this is how people back their way into variance, which they shouldn't have, but,
But I think we can look at that. If it's the same property, sometimes you don't get anything more until unless you're gonna make the whole thing at the end of the day, with this new permit, whatever it is gonna come in compliance. The whole thing's got to be in compliance. So if
That
that's,
would support that one.
you know, if that's what you're thinking, then yes, we can probably get there. But I can't do two unrelated.
Yeah, it's not on the same topic.
Okay, right. I'm sorry, I didn't understand.
Sorry, backing in on the variance, but that's one of the, considerations for practical difficulty, you know, is a self-imposed hardship.
It's not self-created, right?
Variance application not complete,
They should not do that variance application.
which might result in overall structure.
So be it, such as life, right? This is your own problem, right?
So how do I need to reword that? That's nice.
But they should be direct the staff to the extent it's lawful. Okay, that no further permits be issued on the property unless all property will be brought into compliance. Fully.
That's also, no, that's hard of that.
Yeah, and when you ultimately, if you do amend, you do another zoning ordinance text amendment in the future, why don't you throw that into the zoning ordinance as well, okay? Right now, it'll just kind of a general operating policy. But the next time you go to amend your zoning ordinance, maybe with this workable ordinance or whatever, we can tag that along with it, okay? Thank you. Thank you, Nicole. Nicole's like, yeah.
Do you have a motion to not allow additional permits issued, previous permits for big property? Previous permits or no, there's a non-compliance. Not based on a permit, but if they've got a violation or an ordinance. Okay. Violation already, yes. Right.
That's legal and it gets out, you'll see some people at least applying before we go to the site and see 20 storage containers that we didn't know about.
Okay. Most of it's not all permits need to be issued if your violation is already existing on the property.
Unless the new permit would resolve the violations, okay?
Okay.
So if somebody wants to give it.
Right out of space to right here.
Somebody's taking this, right? So, yeah, because what I want is that if they can fix the violation by getting a new permit, if the new permit will solve all the issues, then yes, we can issue a permit, right? So unless the new permit would resolve the violations, right?
See the logic and sense. Call it with that and just hold it. Yeah. All those in favor of the motion? Aye. Any opposed? Motion carried. Anything else?
Well, I have, some news regarding the master plan update, Denise Klein from Mountain Cotton would like to schedule a kickoff meeting, survey questionnaire review, for next month, either on the 3rd or the 7th. So she's currently out of the office, so staff has to, communicate with her and, what days works best for her and for us. So I thought that you should be aware that we're starting to pick up momentum. But plan on a kickoff meeting that she's termed it either on the 3rd or the 17th. Probably be the 17th.
Does that be during our regularly scheduled?
Yes.
Will we give the survey ahead of time or not?
Yes.
Do we have updates on any of the previous
violation that they played out.
So resolution,
The alone we've said. Notice that side we've on two of them, but nothing else to the board.
Specifically asking about it's a safety issue, that's why I'm bringing it up, is Legios and, with the Conex boxes. Right, they've got Haitians and whoever else climbing in out of the Conex boxes that are too tall. They're stacked too high and they get climbed in and out of there, it's a safety issue more than anything.
No, that is zoning violation.
Well, but that's, I'm bringing it up because, but I'm bringing it up more so for the safety than I am anything.
We're gonna have to, discuss, if it's zoning, current of the best. It seems to me that that's right on the upshirt about this storage containers necessarily. You brought that up because.
Oh, there's several issues there.
Railings or anything.
They're too high, they're stacked two storage containers high, back to back. There's 300 storage containers on the property. They poured 18-inch cement slabs underneath them, so they're not movable, they're not meant to go anywhere. Matter of fact, they've got the top one and the bottom one put together. We've got the hotel salvage yard on the same property, that needs to be addressed. Shingles, televisions, refrigerators, hazardous materials, all on the same piece of property. So there's several violations in this piece of property that need to be addressed.
There's also a contract in the believe overly considered.
That's what I was.
It's a junkyard.
Yeah, it's a salvage yard for a hotel. That's the long and short of it. And so there's several violations on the same property, but primarily we got 300 Conex boxes on one piece of property that are stacked too high, and they've got people climbing too up to get to them, and doors open, and it's just there's a safety issue, a severe safety issue. And then you've got, with the shingles and stuff that belong in a landfill, you've got some other issues there too. So
I believe that the permit we issued at that was about 10 years ago.
well, they just built 2-story buildings, 2 big pole barns.
Yeah, but when we issued the permits on that, I think the justification for the new buildings was that didn't have enough storage capacity, and the Conex containers were a temporary measure until they got their new buildings built. I'd have to look back at the conditions we put on that SUP, but it may have been Conex containers are out, but the new buildings are built.
That was my recollection. Planning Commission approved that amendment, and it's the SUP about 2-3 years ago. I can recall off the top of my head precisely what year, but it was fairly recently. So you can take a look at.
I know we cited the junkyard, said that was a violation at the time. In the meeting.
So it'd be a great help if we can get the motion moving, that they can't do anything when it comes back in to do anything else, or we just get that straightened out.
Unless he comes in to resolve all of the zoning.
Right, and we talked about prohibiting some kinds of containers, like Perth Township has eliminated any kind of storage containers except for special conditions.
I mean, I would really think they look gross and and they are all on 18-inch slabs, which I don't understand, but like you say, it's a safety issue more so than me, so that's why I bring it up. And then the old 2 Mile Inn property, have we sent them a notification?
I don't believe we have it. I'll talk to that person noise.
You know which one I'm talking about on 23.
Yeah.
You will.
I don't wanna hear me. Maybe go along on the Trent Township. Solely program. Apologize, I wasn't at the last meeting, so I just have a couple of quick questions. So the approval has been given to the solar project. Already signed. Is that, was that issue of the SUV? If it's not a new plan. No. Just on that, I mean, it's approved under the conditions of 1732. Okay, so it's not, no. There was a, remember going around with these white binders for this project, are these available to the public, for the public, for readers?
So, yeah, the application.
You have one? Oh, is that the sort of thing you should?
Yep. All information received today is.
Is the environmental impact study in there somewhere?
I don't believe there are any formal environmental impact studies as of yet, because some applications to be DNR Eagle.
Okay, so that would be through the local office of, or is that gonna go downstate?
That I don't know.
Yeah, thank you.
Yeah. And I messaged Michael about this earlier, but I think there was some waiting about my question. When we had the public meeting on the Great Solar Project at high school, you had mentioned in your opening remarks that there was, I think this was on 233, okay, and you had said that there was a petition that was that at the state level.
So there was a petition circulating in the state for people who wanted to repeal, put on the ballot for this November, the repeal of Public Act 233. They had to get like 450,000 signatures by a certain date earlier this year, so it could go on the ballot in November. They did not get the number of signatures. I understand there are still people circulating that petition. I forget what Citizens for
Citizens for Local Control.
Citizens for Local Control or something like that. If now, the next time they can get this on the ballot will be November of 26. So, there's still a period that may happen, but in the meantime, between now and November of 26, it's likely some projects or a lot of projects will be approved. So, just so you know, that was a real push earlier this year. I can't remember when the deadline was, but it was sometime in the spring. They did not get enough signatures, like anything to put us on the ballot for everyone in the state to vote on. That's what it was.
Doesn't it seem odd considering all these townships are pushing that?
Like I said, I'm the general counsel for the Michigan Township Association.
Yeah.
I know how organized and strong that response was.
Yeah.
It just wasn't enough.
Yeah.
So whether or not that will be successful or continue, I can't say.
Okay. All right. And I just wasn't sure if you were aware that the Mackinac Center for Public Policy, I know you said this council, you follow what's happening legislatively because your firm represents so many companies that are impacted by this. Do you follow their studies at all? They just came out with a pretty impactful study about the energy impact to the state of Michigan with these net zero goals. They actually did a presentation in front of the energy group at the state, at the House. So I wasn't sure if you.
No, I haven't. Let me make clear. I am on the side of municipalities, so I'm not on the side of businesses. I represent not only Michigan Township Association, but then I personally represent municipalities in our state. So we are only on the side of municipalities in this and every other representation we do. But no, I've not seen that. I'm sure I'll hear about it.
Okay.
But, it's something that, whether we understand our legislative process or not, it's here and as a a municipal attorney, we want local control. We want the ability for our local municipalities to make their decisions on land uses and everything else. And unfortunately, this is just one loss.
Yeah, yeah.
You know, the Michigan Township Association fought very hard against this statute. And it passed anyways.
Yeah.
So, yeah.
Thank you. It's a real a very comprehensive study, so it's a YouTube article or something like that. There's a lot of statistics in there by experts in the field, not just somebody that's looking at it one sided. So I'm sure they're really good at that. Thank you.
I just have a suggestion for is actually when you're considering your ordinance to solar, I would suggest that you take it out of SCP. Because what I'm hearing is that the lack of funds to enforce anything for SCP is the real problem. And if we break this down as simply a money issue, my question would be, would this group of folks here with the commission have the ability to enact a special use tax? So that if we're going to issue this to you, you are going to pay extra over and above with that term excise tax to help offset the cost of the monitoring. I mean, your crop just quoting, you said it's a free for all. You know, what I'm doing is essentially going back to an SUP and a site plan review. Okay. But we can't come up with a fee for them coming in for that. It's going to be any more than what we already have. Wow.
That's true.
Right.
You cannot put a tax on that, but
You call it a fee.
well, what we can do for process the application, yes, okay. But what we do is I mentioned is we will have agreements for the decommissioning, we'll have agreements for the vegetation.
But is it not correct that anything over and above the requirements in the Trio is voluntary on the party?
Well, they're talking about getting rid of that ordinance and going to a different kind of ordinance, which would, as you say, make it a special use permit. And that
It's going to go to the state.
they won't, I'm telling you, they probably won't.
The two that are over here, the other two in the county, they're going straight to the state.
They might be sorry.
They're already settled. So.
Well, and so I guess that's the choice. I don't know why they would. There's a Creo in place now.
Okay.
Which there's no choice.
Awesome. Thank you.
Okay. Right.
Yeah, living that found it as well. I'm just really, I'm understanding how we could change from agriculture to industrial and have 3 landowners impact the entire community. I don't understand it. And now I hear tonight how you're having such a difficult time with violations. And so how is this going to get monitored? How are we going to, they're saying they're going to put trees up and they're going to stand there. How are we going to monitor that when you're having such a difficult time with everything else? I'm really, and you talk about light. What do you think solar panels are? I mean, that's just, and then the runoff into the waterways. It just makes me sick that this has been approved.
A suggestion would be to go to the county board of commissioners and see if we can get an enforcement person that we've been trying to get us for.
Well,
that may help. Talk to your commissioner and say, hey, they need some help.
Okay, I would do that, but it certainly would have been nice to stand up to this and just say no.
Yes, you could. No, sorry. Online. I was looking at planning commission, I only see like 4 people that have been here a while. But that, in those days, the lawyer, the county commissioner, sat in on the meeting. It kind of, in between, kept the county commission informed, I thought. It's right behind you. That one's here. Oh, right here. He's military.
Tonight, I'm going to stop. You know, you're right.
Yes, I know.
Nope.
Public comment? Else for the board?
Welcome, we're here.
Here.